Okay, but Ms. Harris, one of the difficulties that I think is, and this kind of takes Justice Gorsuch's question one step farther, is in this case I know we're talking about marijuana, but obviously the statute applies more broadly to other things that are scheduled, some of which can be taken lawfully or unlawfully. I take it you're saying marijuana can never be lawful because it's on Schedule 1, and even if it's on Schedule 3, the government's saying it wouldn't be lawful. Justice Sotomayor asked you about someone who takes Ambien to sleep. So let's assume that someone takes their spouse's Ambien prescription. The spouse takes it too, lawfully, with the prescription, but then, you take it unlawfully because you break into your spouse's Ambien jar. So I take it that the one would fall under G3 and the other, who had the prescription, would not. Right?
That's correct, because for one, it would be illegal, and then there's sort of ancillary questions about the use by one of habitual drugs.
Okay, but I guess my question is, I agree with you, and I think this is what Rahimi says, that legislatures can regulate to keep guns out of the hands of dangerous people. But when I look at this statute, and when I look at what the qualifications are for being listed on one of these schedules, they're all about public safety, they're about reducing addiction. And the example that I just gave you about the Ambien is important to me because it's not the drug itself in this circumstance that's causing the dangerousness. It couldn't be, because if my husband has a prescription and I don't, what is it about Ambien itself that would make one of us more likely to be dangerous? It's not, it's the lawfulness. And so too here with the marijuana, I just don't see anything in the scheme that actually reflects Congress's judgment that this makes someone more dangerous.
Okay, let me help in a couple ways. One is, I think that there's two parts of this. One is the fact that the Controlled Substances Act scheduling scheme does consider the long-term effects of use, I think is important. I think that is important because it does reflect a determination that especially if you are regularly and routinely using these illegal drugs, there are serious side effects. I would point you to the Third Circuit's Harris decision when you look. If you think that there should be a more tailored assessment of who is dangerous, their questions are replicating the very questions that are being answered through the Controlled Substances Act regime. And second of all,
the Third Circuit's not Congress, and nothing about the scheduling process suggests that the Attorney General or his delegee has to make a decision that a drug, that the psychological effects, I agree with you, everyone would say that any drug can have long-term psychological effects. But there's no indication that that's what was motivating the Attorney General or Congress. This just wasn't about, the Gun Control Act just wasn't about dangerousness. It wasn't something that the legislature thought it needed to consider then.
Respectfully, I think these are on all fours with respect to considering dangerousness. In the Gun Control Act, the fact that it's habitual users or addicts, and I think under the theories that are being floated, you would have a real problem justifying even disarmament of addicts under G3, because I think that it's reflecting a determination that frequent and habitual use of illegal substances, not only above and beyond the determinations that are made to schedule them, but potential involvements of the illegal drug trade are a real problem. And just one other point on this, I think this is a smaller gap in between the move that's being made that's supported by post-ratification history making the same judgment in state after state than what the court did itself in Rahimi, where, again, in Rahimi, there was no founding era history of disarming domestic abusers at all. It was treated as a much lesser offense. It was punished, if at all, by surety laws, and the court relied on the going armed laws as saying that's an even sort of more different danger. The danger there is brandishing your weapon publicly to terrorize a people, versus in Rahimi, it can be sort of conduct in your home. So I think if you're looking at the fit between the danger involved and here, I think that provides it. And just one thing on like how would you otherwise figure out who is dangerous in this situation, I really don't know how this would work on an individualized basis. The Third Circuit's approach seems to rely on like the kind of pharmacological judgments that are already being made within the Controlled Substances Act. But how are you going to find a reliable way of figuring out this person had a particular type of marijuana or other drug from an illegal source? At what concentration? Who knows? At what point in time? Who knows? If there is some sense that you have to have a dangerousness determination for each type of person to track it, I think that's
what about each kind of drug? Is it the government's position that if I unlawfully use Ambien or I unlawfully use Xanax, then I become dangerous?
I will just point out we have never prosecuted anything
well,
beyond
but the
Schedule I
question
or
is,
Schedule
would
II.
it violate the Second Amendment? And what is the government's evidence that using marijuana a couple times a week makes someone dangerous?
Okay. Just with respect to marijuana, I'll take that first, but I'll just say, like, my backup is I think Schedule I, II, and for marijuana, we have not made a policy choice with respect to what's happening, but I think we could very easily justify those threshold categories, whatever you want to do with further down on the schedule. The reason is, for the dangerousness, all of the things that go into the scheduling decision include potential for abuse, the effects of potential addiction, all sorts of things that go into the same kind of calculus that went into the presumptive disarmament of the mentally ill, or other things that affect your mental capacity and affect your ability to use firearms safely. And so if the court is saying, well, mind-altering drugs aren't a sufficient proxy for dangerousness, or Congress cannot make a determination, including one that's backed by the executive branch scheduling process and judicial review, that these types of illegal drugs not only have particular mind-altering effects on the body that can create a serious hazard for firearms use, as the court sort of precedent